path to winning isn't easy. Can an ERISA disability claim administrator like Sedgwick get away with a denial based on a non-specialty IME in an RSD claim? Well, unfortunately, we have case law that addresses this issue. And I'm going to talk with you about a Sixth Circuit case called Avery versus Sedgwick. And I think the court got it wrong. So let me tell you about this story, and I'm going to make some observations about this case and make some recommendations for how you should be handling your claim or a denial or termination. Ms. Avery developed advanced peripheral demyelinating polyneuropathy of her lower legs as a result of an ankle fracture. Her disability policy was administered by Sedgwick, and Sedgwick's known for their biased claims administration. Now, she was paid 2 years of benefits using the standard of disability, which was a disability. She would be disabled if she was unable to do her own occupation. That definition of disability changed from own occupation to something called any occupation. Now, the games that disability carriers play at this stage is to create medical evidence that you can do sedentary work, notwithstanding what your physician has to say. They're going to use liar for hire doctors who will review the medical records, or they'll use not so independent medical evaluators to give them an opinion that you can do at least sedentary work. Then, of course, the game is you've got to appeal that wrongful denial or termination. And if you're not successful, you have to file a lawsuit in federal court. And generally, you have to overcome an arbitrary and capricious standard of review. Under the ERISA regulations, unfortunately, you don't have a lot of protection, if you will, but there is something called the substantial compliance test. Again, the ERISA statute is a statute that has been interpreted by the court. And this substantial compliance test in determining whether or not the disability carrier plan is right or wrong is a test that has no basis in the regulations. It's something the court made up. And so in Ms. Avery's case, Sedgwick had her undergo a liar for hire IME with a physician who was not a neurologist, and then had the IME report in her medical records by neurologists who opined she could do sedentary work. So what the Sixth Circuit did is they said, okay, well, Sedgwick had a paper review, and they didn't really rely on that paper review. But they still had a neurologist review it. They had this non-specialty IME, and we get that that's not kind of the thing to do. But after this non-IME specialist, meaning Sedgwick, had it really re-reviewed, if you will, by neurologists. And so they may not have gotten it right the first time. They had a non-specialty IME, and they didn't really kind of rely on that, but they did it right the last time when they had all of this re-reviewed. That, in their opinion, was substantial compliance. Now, I don't really think that's right for a number of reasons. One of the things that the regulations do say is that the disability carrier has to give you an explanation and produce documents, which is the basis of the denial. And I don't think the denial letter in this case really set forth all the game playing that went on in this particular case. The other thing that I would have done, and I'm not criticizing Ms. Avery or her attorney, would have been to get what's called a functional capacity evaluation to document her functional restrictions and limitations with the polyneuropathy. I would have been attacking the basis of the opinion that she was capable of doing sedentary work. Sedentary work does require sitting. And if you've got peripheral neuropathy issues, you have a painful condition, and you've got to get up and move around. And this analysis is applicable in all sorts of cases, be they Ehlers-Danlos cases, complex regional pain cases, fibromyalgia cases. If you have symptoms that prevent you from engaging in sedentary employment, those want to be emphasized in your medical records. Now, part of sedentary employment also involves bilateral manual dexterity, because you're sitting and you're doing something with your hands. That can be problematic, obviously, in a peripheral neuropathy case if it just involves the lower extremities. but the fact that you would have to get up and move around can impact your ability to do sedentary work and meet the pace and production requirements. So I really would have been going after that. Also, I would have tried to tie it in with a vocational opinion that would have addressed why, based on even sedentary potential restrictions and limitations, you couldn't do full-time sedentary work on a competitive basis, meeting the pace and production requirements. And so I think the court got it wrong for a lot of reasons. They didn't really thoroughly look at the quote-unquote analysis the disability carrier or plan, in this case, Administrator Sedgwick did. And they kind of used this substantial compliance argument as a way to dust this decision off, if you will, with some of the problems and say, well, ultimately, at the end of the day, they substantially complied, when in fact they did. I would hope that courts would give cases like this closer consideration because the ability to do sedentary work can be significantly impacted by any neuropathy-based claim. Got it? I've hopefully given to you a roadmap as to how disability carriers or plans look at these painful condition claims, use position papers, use liar for hire IME doctors, change their reasons for denial, and then hope that the court will uphold a denial. I hope you've enjoyed this episode of Winning Isn't Easy. Please subscribe. Please tell your friends and family about it. And I look forward to talking with you in our next episode of Winning Isn't Easy.